Greer versus Advantage Health. Let the, okay, you may proceed. You may proceed.
Court.
He will return.
Marcy Matson on behalf of Dr. Avery and Advantage Health. I take it we are waiting for Justice Czar
No.
to return, or no?
Please proceed.
Thank you. I'd like to just, first of all, if I may reserve some time for rebuttal, I'd like to do that.
You may if you can.
Thank you very much, Justice Young. I'd like to briefly touch on the set-off issue first. As this court knows, in this particular instance, St. Mary's and Dr. Avery were jointly and severally liable to the Greers for the injuries incurred in this case. Prior to trial, the plaintiffs elected to proceed with St. Mary's alone, and they entered into a contract where they settled any and all claims. There was nothing in that contract that tried to delineate between the claims or between the particular plaintiffs. After a verdict was taken, the court in the lower court only apportioned $162,000 of the $600,000 settlement in terms of the set-off, and the Court of Appeals reversed that, correctly holding that because of the circumstances of this case, that Velez and Markley had already determined that common law set-off did apply in this case, and that the court in Thick set forth how that should occur. And in Thick, the court indicated, where a negligence action is brought against joint tortfeasors, one alleged tortfeasor agrees to settle his potential liability by paying a lump sum in exchange for a release, and a judgment is subsequently entered against the non-settling tortfeasor, the judgment is reduced pro tanto by the settlement amount. And that is the exact circumstance that we have in this case. Plaintiff argues that somehow the underlying lump sum payment should be divided because there was a confidential Exhibit A. However, that particular exhibit does not appear in the appellate record and cannot form the basis for either the Court of Appeals case or this particular case. And based on the law as it currently exists and as was set forth in Velez, the Court of Appeals correctly applied the parties' contract as written, did not attempt to rewrite it, and took the entire settlement. That being said, I want to turn now to the collateral source issue. In State Auto Mutual Insurance Company, Justice Young, you indicated that the collateral source rule is really designed to prevent double recovery by the plaintiff. And yet, the way that the Court of Appeals interpreted the collateral source rule in this case does exactly that. If we step back for a minute and we think more about what is the point of recovering economic loss, it's to make the plaintiff whole. In Macaulay, this court said that when you're talking about compensatory damages, a party may not make a profit by garnering compensatory damages. The idea of loss or damage, meaning that you have suffered some sort of loss, and we want to put you back into the position that you were when you started. In this particular case, the Greers were insured, and because they were insured, when they went to seek medical care, they were not required to pay the standard or the rack rate for that medical care. They were required to pay the negotiated rate from the insurance company. They were never expected to pay, no one ever paid, nor is it payable, the standard or rack rate. So the jury in this case was given the rack rate, they awarded the rack rate, and then the defense went in and said, okay, now through the application of the collateral source rule, let's reduce the amount of economic damages by the difference between the rack rate, which was never paid or payable, and the negotiated rate, because that constitutes a collateral source. To make that determination, we look at the collateral source rule itself, which is in 6303, subsection 4. Two sentences there. The first sentence gives us the definition of the collateral source. The second sentence excludes collateral source. When we look at the first sentence, it defines collateral source to include benefits received or receivable from an insurance policy. And the Court of Appeals correctly concluded that the Greers actually received two types of benefits from their insurance policy. The first type of benefit was that differential. They were required to pay the negotiated insurance rate as opposed to the standard or WAC rate. That is a benefit that they received. The second type of benefit that they received,
How did that benefit accrue to them as opposed to the insurance company that's actually on the hook to pay whatever the negotiated rate is?
because
In other words, how did it affect their lives in any way? They had insurance, the insurance company couldn't negotiate the rate down, then the insurance company pays the full freight. If they can negotiate it down, they pay the lower rate. If I'm the insured, why do I care what my insurance company has to pay?
because you are assuming that the insurance is then going to pick up that differential. You're assuming that your insurance company is going to pay that differential. Well, for a lot of folks, you know, and Justice Larson, in your example, if Justice Young and I are out in apparent gang activity and Justice McCormick shoots not only Justice Young, but in this example, I get shot too, and we go in and we have emergency surgery, well, Justice Young may have insurance that will pay half of whatever is billed by the hospital. I may have insurance that pays nothing, may not even cover ER care. But in that example, if Justice Young, say his benefit is half of that ER care, if he has to pay the standard rate, then his half is going to be a whole lot higher
I
than if he
get
has
that
to
in
pay
your
the rack
hypothetical,
rate.
but why do we have to worry about a hypothetical when we have real actual facts in this case?
Well, the real actual facts in this case is that the Greers did not have to pay, was not paid, was not payable that differential. Nobody had to pay it.
I'm feeling a lot more pique at this oral argument than I used to.
It's been a rough morning.
My question to you is, the differential, you're right, they weren't gonna have to pay. Their policy was such that whatever the amount was, the insurance company was gonna pay, right?
Well, not necessarily. We know that the insurance company paid, in this case, $212,000.
So if you're
But
telling me the
if
insurance company,
400
if they couldn't negotiate the rate down, they were gonna deny coverage?
Well, the negotiated rate is negotiated before they ever show up at the hospital. In other words,
I understand.
perhaps
I know
they have
do
a
it every
cap.
year, and they negotiate these rates, and they look at, and there's a lot of things that go into it. I'm just trying to figure out, if I'm the insured, and my insurance company says, if you pay me premiums, and you have a health issue, we're gonna take care of your issue, right? As long as it's covered.
It would be nice if it was just that simple, right? But for most of us, it's not that simple. For instance, you may have a cap. What if you have a $250,000
I guess the
cap on
one,
your
let's
benefit?
get ground rules straight. I'm having trouble with the theoretical, hypothetical versus the people in this, the plaintiff in this case. Why should I care about anything beyond what's in their policy and whether that drives the determination of whether this insurance discount is a collateral source?
Well, I think we get back to what Justice McCormick was talking about before, which is not getting trapped in the weeds. We want to know, how does this collateral source rule apply, not only to this case, but to cases going forward? And if
But
you
might
want
it be the case in applying the statute that I actually have to apply the statute to the facts of this case?
absolutely to the facts of this case, but we don't have that insurance policy in front of us. What we know happened is there was never a bill submitted to the Greers, or anyone else for that matter, for $400 and some odd thousand for medical care.
What we have is a jury award for what you call the rack amount, the fully billed amount, as opposed to the discounted rate that the insurance company paid.
Exactly.
So in the context of this statute, there's a delta difference between the two. And so why does the insurance company get to pay the amount, why does the company have the benefit of what it actually paid versus having to pay the plaintiff the delta, the additional amount between what the insurance company actually paid and what the hospital charged, or billed, I should say?
In this particular case, the question becomes, did the Greers sustain an economic loss that is or is not covered by the collateral source rule, right? That's the question. And the Greers did not sustain an economic loss of that differential.
Why didn't they?
Well, that's, yeah, that, I mean,
That
they would
money
say they
wasn't
did.
paid.
They would say that was the actual loss. And, you know, I thought your argument was because the insurance, the discounted payoff rate really reflects the actual, I assume what's implicit in this discussion is the hospital pads their bills, right? And that the, whatever, 425,000 doesn't accurately reflect the loss. But I don't know how we know that. I mean, I don't know how to figure out which is correct. And the reason why it matters is because some of the background norms of the tort system weren't abrogated in the statute, right? I mean, when we think about damages, we wanna send the message to the defendant to spend whatever rational amount will make sure that this same accident doesn't happen tomorrow, right? So how the insurance payoff rate factors into that is kind of a complicated question. So I kind of have to give up on it and just go to the language of the statute, which seems to me to be a mess, right?
Well,
No, let me just finish, because you both wrote great briefs, and you both, like, I can read each one of them and go, yeah, that's a pretty reasonable way to interpret the statute. And then I read the other one, I'm like, so is that. Which leaves me in the uncomfortable position of just trying to figure out which one is right. And then I want to know, if they're both reasonable, what deference do I give to the common law principle in the collateral source rule?
well, I think really what we come back to is the basic principle that a party may not make a profit, right? So in our circumstance, if we're both shot and we both go to the hospital, let's say you have insurance and I don't, okay? The rack rate is $100. I have to pay the $100 because you have insurance. You only have to pay $20, and really your insurance company pays the $20. We both sue because sadly your day gets worse. We were malpracticed upon, but we win our case, so good luck. And we both get $100, right? The jury awards $100 to Justice Young and to me. Justice Young has insurance, so he never had to pay $100. $20 was billed to him. Blue Cross paid it. He has to give back that $20. Well, what happens to that $80? He pockets it. He didn't pay it, he didn't incur it, he
Don't ask
pockets
that
it.
question. The background norms of the tort system ask what amount will be efficient such that risks will be reduced in the future. And we don't really care if he pockets $80 because he was smart enough to buy insurance and I pocket none because I wasn't. That's
Plus,
not really the question.
He paid premiums.
Right.
He spent
Well,
his 80 bucks.
The premium is otherwise, no, he
Taken out of
didn't.
the
The
equation.
premium is otherwise accounted for in the statute because you
Oh,
don't,
good
you
point.
don't count the
That's a
statute.
good point.
So he's gonna walk away with
I
a
yield.
windfall. I paid the 100, I get my 100 back, I come out even, right?
We
But
don't
this is
worry about-
economic loss. This is economic loss, which is designed to put you in the position you would have been if neither one of us got
Doesn't the
shot.
statute,
That's not how everybody thinks about it.
well, does the statute abrogate to some extent the common law rule was that you can have a double recovery, right?
Under the common law,
Yeah.
sure, but now we have the
This
statute.
statute, to that extent, abrogates that rule and provides a formula, an opaque one perhaps, but a formula to reduce that common law double recovery issue.
Exactly, and that's what you said to
Well,
us in state auto mutual insurance, that it is designed to prevent that double recovery.
Then if that's the context of how we have to look at the lens of what this statute is attempting to do we not?
Absolutely, which is why we have the two sentences. We have the first sentence, which tells us, if it's a benefit received or receivable, it is a collateral source. And in this case, the Greers had two types. They benefited from the fact that they did not have to pay the rack or the standard rate, and they benefited from the fact that of the amount that was billed, the rack or the negotiated rate, the insurance company paid $212,000, right? So they had these two types. Then we look at the second sentence, which excludes. And in the exclusion, and the key point that the Court of Appeals missed, is it talks about a contractual right to a lien. The insurance company contractually has a right to assert a lien to get back the monies it paid. It does not have a contractual right to assert a lien as to that differential, because it wasn't paid, it wasn't billed, it's not payable, it's not owing. No, it's
but-
illusory
but-
Couldn't the
because it
legislature have
doesn't
done better? I mean,
exist.
the exception, I mean, it says only that the lien has been exercised,
Right.
right? The legislature,
Well, it actually
says
says
both.
entitled by contract to a lien against the proceeds of a recovery. And there is no lien against the,
But that's not
the-
the end of it. It
Yeah,
says
that's-
the lien plus it has to have been exercised.
right, exactly. And there is no lien because there cannot be a lien against that differential. And the reason, if you think about it, if you step back and you
wouldn't
think
it have
about
been
it
easy for the
globally-
legislature to also say, I mean, it just seems to me, it could have been, this would have been so much easier if the legislature had said, the plaintiffs can only recover the amount of benefits over which a lien has been exercised. It doesn't say that, right? It
would
just
be
says there has to be a
lovely.
lien and it has to be exercised.
It would be great if it was written
I know,
perhaps
but
more
when it's
simply.
not, what do we do? That's the question.
Well, I think we interpret it in such a way that makes sense, right? And what makes sense is we're trying not to have double recovery. And essentially, if you step back, what were they trying to say to us, right? We don't want people to end up with a windfall for economic loss that they didn't suffer. So if a lien has been exercised, right, then the plaintiffs have to pay that money back. So they should be able to recover that money because they're gonna have to pay it back. That's an actual loss, and we don't want them to come out behind. In other words, if we didn't let them recover for these economic damages, they'd still have to pay them back because there's a lien, and they would come out behind, they'd be in the hole.
I get that that's a reasonable, like, that might have been a reasonable thing for the legislature to say, it just didn't quite say it, and it could have.
Well, I
So
think
that's
it
my
did.
question.
I think it did because it says it specifically excludes only those benefits from an entity that is entitled by contract to a lien against the proceeds, and if that contractual lien has been exercised. There is no contractual lien against the proceeds that constitute that differential, okay? There is a lien against that first $212,000, no question. They gotta pay that back. So there is a lien against those monies. There is no contractual right, nor has there been any contractual lien asserted as to the second portion of their benefits, that differential.
Why is
And
a
that makes
benefit?
perfect sense
Why is the
because,
differential a benefit?
what's that?
Why is the differential a benefit? That
Because
between- the
they don't have to
difference
pay that
between-
money,
Sorry?
because they don't have to pay that money.
That's a statutory benefit?
Well, I don't know that it has to be a
I'm trying to
statutory
figure out.
benefit.
Benefits paid or payable.
Mhm.
Why is that what I call the delta between the actual paid medical expenses and the billed amount? Why is that amount a benefit?
That amount is a benefit to them because they don't have to pay that amount.
They weren't gonna have to pay it anyways.
Well, they might have. What if your insurance, Justice Viviano, says you pay 50% of all of your ER visits?
I got you, but if I'm the plaintiff in this case, and you said you lose under this statute because your neighbor has a different policy, I would be scratching my head.
No.
If I had a better policy, I would wanna have whatever benefit that I paid for
But this is
in
a
my
more
premium.
global question, which is it a benefit?
I
Yeah,
sort of
that's why I asked.
agree with you
Right.
that the reason why the legislature did this, and Justice Young laid that out for us as well. And I might even be inclined to say that that was a good thing that they did. If I was in the legislature, maybe I would have voted the same way, but don't we still have to thread the needle through this statute to determine whether the insurance discounts, which are not clearly referenced in this statute, meet all these sections? And so Justice Young brought you to the next one, which is giving me some difficulty, which is not just whether it's a benefit received, I guess, but whether it's a benefit paid or payable. When was
Well-
the insurance discount paid or payable?
That's
In
a
this
very good
process.
question. And if you assume that it's not paid or payable, well, then it falls within the exclusion.
I'm sorry?
But then where it says paid or payable, you're looking at the second sentence in the exclusion?
I mean, it says it everywhere in the statute almost, paid or
Mhm.
payable, right? In the very first section where it tells us what collateral sources are, it talks
And-
about benefits paid or payable.
To a certain extent, that question is moot in our particular case because our entire point is that differential is in fact a benefit received or receivable, so
Why?
it is a collateral
Why?
source.
Why? That's the question asked. Why is that a benefit?
Let me put it to you this way. Let's say you have a garage sale and you have an item marked for $1. And I show up at your garage sale and I say, you know what, I have a quarter. Will you take a quarter for your item? You say, yes, I will. You get the quarter, I get the item, I walk away. I'm happy, you're happy. I have benefited by the fact that you have agreed to give me your item for which you wanted $1 for 25 cents. That is a benefit to me. That is a
Why it
negotiated
statutory
discount.
benefit? The jury awarded a certain amount. Why is that an insurance benefit?
Because the only reason that you get that amount in this case is because of the insurance company having negotiated it on your behalf. Otherwise, you'd be paying the $1. So you've benefited in that example. You have received something of benefit to you because you don't have to pay that differential.
So, can I get back to my question about paid or payable? If you assume it's a collateral source, we'll assume for the moment that you've gotten past, section 4, the definition of what collateral source means, that it's a benefit that was received by the plaintiff. Let's assume that for the moment. In order for then the rule to apply at all, doesn't it have to be a finding by the court that the expense was paid or payable by a collateral source? I mean, do you get out of paid or payable? Am I reading the statute wrong? Don't you have to prove both? That it was a benefit received and that it was paid or payable?
You mean in order for them to actually subtract it?
Yeah, to do the deduction.
Absolutely, which is why the Court of Appeals essentially used the analogy that to pay this bill, that you have the first portion, which is the negotiated differential, that took care of
The
that first
discount.
section, and then they paid actual cash money that took care of the second portion.
So
And
then
if you
by
look-
negotiating, we should consider that a payment?
Absolutely, and that's exactly what the Court of Appeals held. And the Court of Appeals looked at the dictionary and essentially looked at Random House, it looks like, in order to come up with the idea that pay is broader.
I wish I could convince my car dealer that when I negotiate the price down, that I'm still paying them,
Well,
the sticker price.
if you look at it a little bit more broadly, if your
I
car
try.
dealer says to you, okay, the sticker price is 10,000, but we'll take 8,000, their decision to drop the price is in essence a payment of that differential, because they're not coming after you for it. It was the original price. It's not
Or
anymore.
maybe they just agree that that's the market price of their product, is what a
Exactly.
willing buyer would pay and what a willing seller would sell the product for. And there was no other payment other than the actual payment. Maybe, or am I
Well,
looking
this
at it
gets
too
back
narrowly?
to the circular
But this is
nature
a
of the
really
way the
important
statute's actually
circular
drafted.
argument you need to break.
Pardon?
It's a circular, it may be tautological, but you better break the tautology.
Well, and that's why there are two separate sentences. And one refers to benefits received or receivable, and one refers to benefits paid or payable for which there is a contractual lien.
Well, but again, you've not done very well, at least in explaining to me what you've described as circular. You're describing the thing not paid, the discount, as a benefit.
It is a benefit.
I know you say that. I don't know why it is, but you say it is, and I'm confused. Now, you're going to turn to the second part of the clause, and what is that? The first sentence, rather. What's your argument under the first part?
The first part of the second sentence?
Yeah.
The second sentence is intended to exclude from collateral sources any monies that essentially the plaintiff is going to have to pay back. The reason being, we don't want that plaintiff to end up in a hole, right? We want that, but we want them to end up whole. We don't want them to end up on this side where they make a profit. In Macaulay, which is 457 Mich. 513, this court very clearly said that a party may not make a profit by the recovery of compensatory damages.
What is just for round numbers, let's say the rack rate is 4 and the actual charge is 200, half there is the plaintiff has the right under the statute to recover for, quote, the expense of medical care. Is the expense of this medical care 400 or 200?
To this particular plaintiff, it would be 200, because that's the amount that the insurance company is going to pay and that they are going to be able to recover, but under the collateral source rule, keep, because then they have to give it back. So they end up not having paid anything. But if you give them the entire 400, they have to give back 200, because that's the amount that was paid. Then what happens to that other 200,000? They pocket it, and then that's a windfall.
But I don't, it may be, but I don't know whether we get to take it, claw it back under the statute.
The common law rule was that we didn't really concern ourselves with that, because we believed that we wanted to make sure that the amount of the loss accurately gave the defendants a signal about how much to spend to prevent it in the future, right? So that was why the common law rule let people benefit from the the discount, right? There was a reason for it, and those background norms of the tort system didn't go away. And my question to you is, when we're interpreting a statute that's confusing like this one, this court has said if there's any doubt, the statute is to be given the effect that makes the least change in the common law. So if there's doubt here about how to think about this, why shouldn't we give effect to those common law norms?
Because we know what the statute was designed to do.
But we don't, that's why
We
we're here.
know-
If we knew, we wouldn't be here.
Well, we know because Justice Young told us in State Auto Mutual Insurance that it was designed to prevent a double recovery by plaintiff.
But maybe it doesn't do it well when it comes to insurance discounts. It does it well in other areas, but maybe not.
Which
Well-
might make sense, because it's a complicated secondary market about which, we don't want to have to learn the policy for, right?
I think it actually does it fine. I mean, Justice McCormick is right. I mean, anytime you go back and you look at the language of a statute, you say, oh, maybe we could have written it a little bit differently, but it accomplishes its purpose because it tells us if these benefits are received or receivable, then they are a collateral source, and if the benefits are subject to a contractual lien, then we don't deduct that amount. We let the plaintiff have it because the plaintiff's going to have to pay it back. It sets it up very nicely. It's two separate sentences. It tells us, okay, this is collateral source, this gets reduced unless there's a contractual lien and the plaintiffs have to pay it back. Because if they have to pay it back, we don't want them to come out behind. We want them to come out whole.
Counsel, I have a
Not behind,
question.
not ahead.
I'm sorry, I think someone else had a question, though.
Go ahead.
No, it's
Oh,
all
I
you.
could just sense that someone had a,
But she's into her rebuttal time.
oh, do you want me to, I'll wait till your rebuttal time.
Okay, thank you, Justice Bernstein.
May it please the court, my name is, excuse me, Jonathan Damon, and I represent the Greers in this case. I would like to make a couple corrections of what counsel said to you a few minutes ago. She stated that the negotiated rate and therefore the discount was negotiated on behalf of the Greers. That's inaccurate. The Greers did not gain a penny by the negotiated discount. The only party that gained by the negotiated discount was the insurance company, which was obligated to pay all of the medical bills. If there had been no negotiation, the insurance companies in this case would have had to pay $425,000. The insurance companies were able, through their power of purse or whatever, to reduce that figure. That benefit did not in any way inure to the benefit of the Greers. It only benefited the insurance companies who were responsible for paying the entire $425,000. I'd like to make another observation. Now, first of all, let me point out, the medical expenses in this case were stipulated to by the defense at $425,000. This was not a situation where there was necessity of presenting evidence of the various medical bills and all that. Mr. Berry, representing the defendants, stipulated to it, and we pointed that out in the record. Finally, counsel argues that if these benefits are paid or were not paid or payable, and she argues, it says this discount was not paid, obviously, and it was not payable. If that's the case, then it doesn't even fall within the statute, because it doesn't fall in the definition of a collateral source at all. Putting aside the question of the lien, it doesn't even fall within the definition, and therefore we return to the common law. It's interesting, I think, and ironic somewhat in this case, because there are two issues before you, and I'll speak to both as counsel has done so already. And one case is involved in both, and that's the Velez versus Tuma case. Counsel has cited it with regard to the set-off issue, and I've cited it with regard to the present issue, given the fact that it sets out recent rules regarding interpretation of statutes which are in derogation of the common law. We know what the common law says. It's quite obvious that this statute is in derogation of the common law in as much as it partially abrogates the idea that a collateral source is not to be deducted from the recovery by the plaintiff. And I use the word partially because the insurance payment, whatever it is that is claimed to be a collateral source, must fit the definition of a collateral source. And as I just pointed out, amounts that are not paid, the discount, or payable, the discount, don't fit the definition of a collateral source. Furthermore, there was a lien, liens, actually several liens, by the insurance companies. In this case, I believe they were RISA plans, but they're basically insurance companies. And I believe that under the last statute, or excuse me, the last sentence of Section 4, that removes the whole issue, payment or non-payment, from the definition of collateral source. We don't even apply the statute unless there is a collateral source. And when the statute says a collateral source does not include amounts paid where there is a lien asserted, it's not a collateral source. The defense in this case would have you rewrite the statute. And there may be legitimate policy arguments to do so. I'm not going to deny that the arguments made by counsel and by the defense and by amicus on the defense side in this case do not have rational arguments to make. I believe this is the wrong jurisdiction to make them, though, the wrong venue. Those arguments should be made in the legislature to amend the definition of collateral source, or simply to provide, as I point out in my brief, to add a few words to the end of subsection 4, and that is simply say that the lien is asserted to the extent of the lien. And that is the extent of the exception set out in the last sentence of section 4.
Well, given that the first sentence defines collateral source as benefits received, not as an entity of some sort, but in terms of monies, why isn't that a reasonable understanding of the last sentence?
I'm sorry, I didn't quite understand that. The benefits received by the Greers?
Collateral source is not defined as an entity, it's defined as benefits received. And I'm wondering what words is opposing counsel putting in the last sentence of section 4?
I believe, and
You're
it speaks to
suggesting
the
she's,
I'm sorry.
go ahead, please.
It speaks to the question of the lien's assertion. And she argues that because the lien could only be asserted on the amounts paid by the insurance companies, that therefore those amounts not paid by the insurance companies.
Are there liens asserted here?
No, the liens were asserted by the insurance companies to the amount that you've got before you, the
Okay.
$200,000.
But then I think counsel's statement is accurate as to the differential. There are no liens and no liens asserted as to those.
There are no
amounts.
liens asserted to those because there was no payment made for those. In other words, the
But it
lien
isn't,
was asserted
and it
for
isn't
the-
a benefit in your view either.
It's not a benefit, but in addition to that, it doesn't say that the lien must be asserted to the extent of the amounts paid. The
Oh,
last
so
sentence-
any lien negates the entire provision.
That's the way it's written. And counsel would have it be written where it says the lien is asserted to the extent of the payment. but that's not the way it is read, or is written.
Did I understand you to say that you believe there was a stipulated admission that precludes the insurance company from seeking collateral source in this case?
No, I'm stating that the amount, you brought up the issue in the Wrongful Death Act of the medical expenses, and the medical expenses in this case were stipulated too for the trial, which is what the jury returned of $425,000.
Okay, but that.
This was
you're
not a part, no, they didn't, no, as a matter of fact, in the stipulation, counsel expressly reserved, with our permission, the right to raise this issue.
All right.
Is there anything, in my experience, that's fairly common to stipulate to the medical bills, but is there anything that would prevent, and maybe I should know the answer to this, but is there anything that would prevent defense counsel from contesting the amount of the medical bills as part of the trial and sort of raise this argument that, hey, look, what they bill is not really the value of these services. They have a schedule and they're only gonna pay, and so the real value of the services provided and what they will actually have to pay is half.
I believe they certainly have the right to challenge the medical bills. I mean, they have a right to make the plaintiff prove the reasonable necessity, the reasonableness of the bill, all of that. It's seldom done because generally people accept what the medical bills are. They've seen the medical bills as exhibits. There is something, and I believe it is the part of the rules of evidence that would preclude them making the argument that these are really not the medical bills are half because of the insurance, because first of all, it brings insurance. The only reason there's a discount is because there's insurance. If there was no insurance here, the Greers would be on the hook for the whole $425. If the negotiated discount had not occurred, the insurance company would be on the hook for the whole $425. And in addition to that, the Tort Reform Act provides that the collateral source hearing occurs after the initial trial. And that's where you have a hearing to determine a number of things, which occurred in this case. One of those being the deduction for collateral sources.
Could you address what the statute provides that the plaintiff can seek to recover, quote, the expense of medical care? Can you address why the $400,000 fully loaded billed cost versus the $200,000 actual cost is the expense of medical care in this case?
Because the $200,000 is totally dependent upon the insurance coverage. Some people have it, some don't, but it does not say the amount, and the wrongful death statute talks about the expense of medical care.
Mm-hmm.
It does not state anything about the amount as to who is going to pay it.
But I mean.
But it's still an esoteric question to a certain extent, right? Because expense might mean, I mean, I think, I don't know, it may well be that medical care is overbilled and the true expense really is the discounted rate. Like if the discounted rate really does reflect the real expense, should I care about that? Maybe not, given what you've said about the imperfections in the statute, and but since we're here,
Well, the
I mean, if
defendants
the
can
discounted
challenge.
rate really is the real expense,
Yeah, the
should I care?
defendants can challenge the reasonableness of any medical bill.
Oh.
There's nothing that prohibits the defendant in a malpractice or any other case from saying, we believe that that bill is not the correct bill, it's too high.
Right, but I thought your answer to Justice Viviano said that they couldn't do that. They couldn't argue, for example, that the price is inflated to reflect
No,
the fact
I must have
that there's-
misspoken. What I mean to say is, they can challenge it with evidence. The evidence simply does not include the insurance company. There's a statutory prohibition on that. There's a
Right.
rule of evidence, I believe, regarding that, payment by others.
But, okay, but what if they were to bring in evidence, I mean, I'm sure they wouldn't have this, but evidence that in the aggregate, medical bills are inflated because we know how the insurance industry works in the aggregate.
You're not supposed to do that in a tort case, but I mean.
Not that either.
The
Okay.
issue of insurance is precluded by
Okay.
statute and quarrel.
Fair enough.
But they can do it, and in fact, they do it in the no-fault Let's take no-fault insurance. No-fault insurance companies consistently do exactly what you say, and that is challenge the reasonableness of a particular charge. They have auditing companies that audit the bills that are submitted for payment by the no-fault insurer, and they will send these to the auditing company, and they will do whatever it is they do, and come back and say, we don't believe that is a reasonable figure for the service which was provided. They will also come in and say that service was not reasonably necessary for the persons in care. So bills in all fields they aren't conclusive. They can be challenged, but they can only be challenged by certain types of evidence.
Right.
And the insurance payments are simply not one of those. The other issue, I think I've already mentioned, that there's an argument here that this gives an absurd result. First of all, I don't think it's any more absurd than the common law rule, which has stood for many, many years, where the injured person gets the benefit and gets to keep all of the money. But if it is an absurd result, it's something that should be addressed to the legislature. The arguments made by counsel should go to that forum and not to this forum. With regard to the set-off question, counsel has cited and the court relied upon the Velez case, but Velez is a case in which there were multiple claims, but by one plaintiff. I searched Westlaw.
I agree that that's an important way of distinguishing it, but we have on this record one set-off amount. And just a moment, there is nothing I'm aware of that allows anyone, including us, to allocate that undifferentiated amount. So I really wish you'd address that. I understand that we only had one entity in the other case, but here the parties, as far as the record is concerned, did not make an allocation so that it's clear that what part of that might have been attributed to different parties.
I believe that's not quite correct. There was an Exhibit A which Judge
It's not in the record, is it?
It is not in the record,
Well,
but
then
the
it isn't.
judge's findings based on that were.
Well,
Judge Redford's findings.
that may be the case, but if he's making it on extra record basis, then it's not justified, is it?
Well, I believe the person challenging Judge Redford's decision, Judge Redford made a finding of what the amount of the set-off would and should be. The challenge, if that's to be challenged, must come from the defendant.
I
The
think it
defendant
did.
never
It is.
asked for Exhibit A.
The challenge is, there is no basis for what the judge did.
I guess I have it was a confidential settlement, and I'm not going to argue that Exhibit A is in the record. Reference to Exhibit A is rife in the record. Judge Redford expressly based his decision on Exhibit A, but I do agree, Exhibit A is not part of the record for the reason that it was supposed to be a confidential settlement. I'm not sure how confidential.
Well, then I appreciate how this decision may have transpired, but don't you bear the risk of loss if there isn't a basis for the calculation in the record?
I don't think we should bear the risk of loss. If in fact there is a question of fact regarding how that apportionment occurred, I would simply ask the court to remand the case.
Were you not asked to provide that exhibit?
No, we were not.
Okay.
That's one thing. There was an intimation in one of the briefs that there was a subpoena issued. I looked through the docket entries and could find no such reference, and I talked with Mr. Waddell, trial counsel, who has no memory whatsoever of ever receiving a subpoena for Exhibit A.
Okay.
Furthermore, there was a substantial amount of time that passed that counsel for defendant, not present counsel for defendant was well aware of Exhibit A and simply did nothing. Does the court have any further questions? Thank you.
Justice McCormick,
You have 2.5
perhaps
minutes.
to your question in terms of the legislative intent in this case, I would also refer you to page 6 of our brief, which is the Senate Select Committee report when they adopted this particular statute, and specifically to the sentence which says, "The proper measure of the liability of the defendant should be the extent to which the plaintiff suffered uncompensated pecuniary out-of-pocket losses." And that's really the point of our argument,
It would
which
have been
is,
better if they'd said that in the
Yeah,
statute.
we're just left with the plain language of the statute, that's the problem.
well, the
Somebody
statute
else probably
is,
said something differently, I've read all those articles, so.
sure, and the statute is easily interpreted to be very consistent with its intent, which is, the first sentence talks about benefits received or receivable, and the second sentence specifically includes that there has to be a lien, and the lien has to be asserted. And I would differ with my brother counsel in that the statute specifically talks about the collateral source, that portion which does not fall within the definition of collateral source would be that the benefits are ones that are paid by an entity which is, and this is the key portion of that statute, entitled by contract to a lien against the proceeds of a recovery. And in this case, there is no contract that would entitle the health insurance company to assert a lien against that portion of the recovery which represents that differential that was never paid.
So that's how you get a distinction between a lien for a particularized portion. There isn't a possibility for lien against this one.
Absolutely.
That's how
And
you
the
fill the
statute
to the
very,
extent of, that's how you fill the to the extent of gap.
absolutely. That's absolutely it. And that's what the statute says, and it specifically refers to. And interpreting it this way is very consistent with the purpose, which is that the plaintiff does not end up with monies that it did not pay out of pocket. So it's very consistent to interpret the language of the statute with the purpose behind it. And I know, Justice Bernstein, you had a question.
Yeah, when I realize this, I'm trying to look at this from a broader, kind of bigger picture, but what I'm trying to grapple with, and this might start off simplistic, but I just want you to follow me for a second. What is the actual cost?
The actual cost?
What is the actual medical cost?
The actual,
Is it the medical, yeah, I mean, I'd like to kind of get a sense from you. Just what is the actual, when you get a bill from the hospital in this situation or in other situations, because you said you wanted to kind of be more general, what is the actual cost?
the actual cost is the amount that is going to actually have to be paid. No different than if you go to Meijer and you buy something on clearance, you get the receipt and it will say, was, $10, new price, $7, and then it will show you, you saved $3.
Okay,
That's the same thing. Well, what is
Okay.
the actual cost to you? You
okay,
paid
so,
$7.
okay, so follow me just for a second, because this is where I think sometimes life experience has an impact on making judges look at things in a good way, in terms of the life experience that they're given. So let me just walk you through something, and I want to see how we can apply this in a more general landscape based on your request when you were talking to Justice Viviano. So I was in the hospital, I had a catastrophic injury, I was in the hospital for 10 weeks. So I got a bill from Mount Sinai Hospital for a 10-week hospital visit. Here's my question to you. What is the actual cost? Is the actual cost the amount of money that was sought after in the bill from Mount Sinai for a 10-week hospital stay? Or was it what Blue Cross negotiated with Mount Sinai as it pertained to a 10-week visit, or 10-week stay?
Well, I suppose you start with the premise that the cost is what's billed, right? And then the expense is what has to be paid. So you've received a benefit because there's a differential between the cost and the expense. So you've received that benefit, so now you've received the benefit, so you're in the collateral source.
Okay, but let me
But-
take you one step further. What if there was, let's say I didn't have Blue Cross. What next? How would you apply that? Let's say I didn't have Blue Cross Blue Shield, or I didn't have insurance. How would I apply that? How would that apply to your argument as it pertains to the cost, to the bill that is now being presented to me from Mount Sinai?
Sure, well, if you don't have Blue Cross or Aetna or anyone else, your cost and your expense are going to be the same, right? Because you're going to owe that money. So when you go in front of the jury, you're gonna put that number in front of a jury. There's no collateral source because you haven't received any benefits from the insurance policy. And so, that's the amount you have had to pay out of pocket. And under the
What if
purpose
he
of the
doesn't have to pay
statute.
because he has a really nice church group? I know you don't go to church. But what if he does? He has a
I
really
would go
nice
in
church-
it.
He has a
Let me
really
tell you-
nice church group and they'd say, I feel really badly that Richard had a 10-week stay and has to pay all this money. And so we're gonna have a really, really, really good bake sale, a really good bake sale.
And I would totally
Those are
go
good
for that
brownies.
reason.
And
got
we're gonna
that
raise the
there.
money and pay his bill. I know that then you're way outside the statute, because the church group doesn't know how to do the lien, and let's assume.
Well, absolutely, and your
But-
church group doesn't fall within the collateral source statute because it talks about benefits received or receivable, and it defines from who,
So in
including in
that
this
case,
case
he
an
gets the double
insurance.
recovery because the legislature didn't think of that.
Well, you can say the legislature didn't think of it, or you can say it's really, really unlikely
unlikely
that
that
you're
they'll
gonna
be able to do
raise
it.
$10,000 in a bake sale. Or you're gonna say, you know what, as a matter of public policy, if we have church groups or, family members or whoever else out there that wants to get involved and help pay, then you know what, as public policy, we don't wanna discourage that. Let's have communities get together and help out each other. But that doesn't have anything to do with the collateral source rule and the more typical, I would say, insurance policy situation where you don't want people to walk away with double recovery. So, as a public policy, you don't want people to walk away with a windfall, but you know what? If you've got a good church group, or you've got a good community, or a good family, as
You're
public
well
policy,
beyond
let's
your time.
encourage that.
Thank you very much.
Thank you very much, Justice Young. Thank you, all of you.
Case is submitted.
Gasping for air. They were told to go call 911. They're going downstairs, and as Melissa's walking down the stairs, she's walking slowly, and Kimberly says she's walking behind her, wondering why Melissa's walking slowly until she sees a figure in front of them too. And Melissa says she sees the who she described as defendant, a person she's lived with for, they're unsure, but it's about 3 years. Before she knew it was defendant by the description or the shape of the body in front of her and the very distinct smell that he had. Kimberly behind her also recognized the person in front of them as defendant. And then they leave the house. The person who left the house knew another exit other than the exit that the two girls were leaving from. And they go to their neighbor's house. And the very first thing they tell the neighbor and the daughter testify that they said that the defendant is in their home. And so we have all this connecting the defendant to the crime. In addition to that, once the lights are turned back on, they find defendant's shoes in the home with the sponge taped to the bottom. Actually found one shoe of a pair. And they identified those shoes as the shoes that defendant wears. All that together, we have motive, and yes, it's circumstantial evidence, but motive and circumstantial evidence carries a case all the time. And while the identification is not typical in the sense of the clear eyewitness identification in a photo lineup, these two girls knew the defendant. They lived with him. When you're in a room with somebody, you know their presence, and they saw him. They said that there was some light coming through, and they saw his figure, and they identified his smell. So when you consider that evidence, in light of the very little weight that the character evidence would have in this case, or has in this case, and then the other instructions read to the jury was told to consider Kim Hardin's testimony, the character witness's testimony. They were told to consider all witnesses' testimony, each piece of evidence to determine whether the defendant was guilty beyond a reasonable doubt. There was no instruction telling them not to consider Kim Hardin's testimony, so why are we to think that they didn't consider her testimony in determining whether the defendant was guilty beyond a reasonable doubt?
You do concede that the character instruction gives a thumb on the scale for the jury giving particular consideration to character evidence.
Yes, and that's why the people believe that the instruction should not be given in the first place. Why are we highlighting this specific piece of evidence when it's not done in any other situation that this specific piece of evidence may alone sometimes create a reasonable doubt? That is not stated in any other instruction in all the criminal jury instructions. And it does put the thumb on the scale, telling the jury that...
But that does make its absence consequential, does it not?
Well, the jury is told to consider each piece of evidence in determining defendant's guilt. And they're
Yeah,
supposed to...
but this one says, this one really look at more closely.
Well,
Isn't that right?
Yes, the instruction does say that. Look
So
at the...
why isn't that a consequential omission?
Well, because other than the fact that it shouldn't be given in the first place, the jury shouldn't be told to highlight any specific piece of evidence more special than others, and it's not done in any other.
No one's argued until this point that
Right.
the instruction was legally incorrect. Nobody said that. There was not an objection in the trial court. You can't give that because even though it's a standard criminal jury instruction, it is legally incorrect because it elevates this form of evidence over every other evidence.
Right, that did not occur.
So that's not a preserved issue, is it? The propriety, legal validity of the instruction is not something that was preserved for argument here, is it?
In the trial court?
Anywhere.
Well, it
You
was,
didn't argue that in the Court of Appeals either.
no, it was not argued in the Court of Appeals. But to determine whether it was outcome determinative, we should, well, first let me answer your first question. Did the last part, because it points to a specific piece of evidence and it wasn't, that part of the instruction wasn't specifically read to the jury, does that maybe raise the bar as to it changing the outcome? And that's, the answer to that question is no, because the jury is already told to consider each piece of evidence and each witness's testimony and to see whether they believe them. And the jury was told in this case, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. So all you have to do is insert that witness's name and they're supposed to do the same exact thing. Now, they're also told what is a reasonable doubt, how that's created. What, you have to listen to all the evidence. Does it create a reasonable doubt? Does the jury also need to be instructed that that alone may create a reasonable doubt? Well, we already know that because they're told that they have to consider each piece of evidence to determine whether defendant is guilty beyond a reasonable doubt. So no, I don't think that not giving that instruction would have changed the outcome. And we have to consider, okay, whether maybe if this court is inclined to say that this instruction should be continue to be given to the jury, and that part should have been read to the court, or to the jury, I'm sorry. We have to see, would that alone would that have created a reasonable doubt in the minds of the jury? And how do we do that? We have to look at the entire cause, all the facts of the case, including what was argued by the parties, what instructions were given, the actual testimony taken, the character witness's testimony, and that was not done by the Court of Appeals. They very summarily stated the facts of this case and left out many pieces of evidence and just said this was largely, a prosecution's case was largely based on motive and circumstantial evidence, and because defendant presented a witness, character witness, and asked for the instruction, there was a miscarriage of justice.
So is your real complaint that the Court of Appeals applied the wrong standard, or is your real complaint that they applied the right standard but inappropriately?
They said the right standard, they said the standard of review, but then they went through Michigan's case law saying that when this happens, it's an error requiring automatic reversal. And then they stated very briefly at the end, regardless, this is a largely circumstantial case based on motive, because of that, and he asked for it, and they gave and he had that witness, there was a miscarriage of justice. But the standard says that you have to look at the entire cause to see if it affirmatively appears, whether it's more probable or not that the alleged error was outcome determinative. And this is a very high standard. I'm sorry?
You have less than 5 minutes remaining.
Okay, thank you. And Michigan courts are to presume the validity of verdicts and to reverse only with respect to those errors that affirmatively appear to undermine the reliability of the verdict. And that's just not what we have here. Even if the instruction was supposed to be given, and most of it was covered in the general instructions, we have to look at the character witness's testimony, and it was very minimal. She didn't even live in the community at the time this crime occurred, or 3 years prior, or 2 years after. She had moved to California. She didn't know defendant. She grew up with him and knew him before, but when this was happening, from the time he met Ms. Kuntz, she wasn't even living in the community. She said she had seen Ms. Kuntz 4 times and had only seen defendant when she would go to his mother's house and he happened to be there. So we consider the minimal character evidence with the evidence of his guilt and the instruction that they were told to consider each piece of evidence and all the witnesses' testimony. I'll reserve my remaining time for rebuttal.
Super.
Good morning, Your Honor. It's Daniel Rust appearing on behalf of Mr. Lyles. Quite honestly, I'm not sure why I'm here. The Court of Appeals, in a 3-0 decision, agreed, and the prosecutor agreed, the jury was misinstructed. This court has asked for whether the evidence, whether the misappropriate instruction affected the outcome, and I would say yes. If you recall, this is a 32-year-old case. None of the evidence was presented except from a memory, a 32-year-old memory of a 13-year-old. I would suggest over the years, memories change. I can give an example, several examples of how a memory can change over those years. They had nothing against Mr. Lyles. The 13-year-old was upset with him. He recalled things that happened in her teenage years. And the only thing Mr. Lyles had to defend himself against was his good character at that time. I don't know what I was doing 32 years ago on a specific day at a specific time. The jury was asked to consider all this evidence. And if I recall correctly, the judge even wanted to bring in evidence that there was a warrant for Mr. Lyles' arrest from 32 years ago. I would suggest that the thumb of the judge went towards the prosecutor. The thumb acted as an input into the jury's consideration of not even to think about Mr. Lyles' defense. He had an opportunity to present a defense according to what he could do, which was his character. Presenting that in front of the jury, and I understand there are problems presenting character evidence before a jury, but that was his choice. The prosecutor seems to suggest that perhaps instructing the jury on this character evidence causes undue influence to the jury and bringing it to the jury's mind. But I would suggest to this panel that the instruction says you can consider this evidence along with all the other evidence. And, oh, by the way, on the second sentence, it may tip the balance one way or the other. But that's up to you to decide.
We don't have any other instruction that I'm aware of that says for this particular brand of evidence, it can be outcome determinative, do we?
That's correct. There is nothing that suggests that. But I am referring to the second sentence of the first part of the jury instruction.
No, this
Okay.
is a singular instruction when all of the ones that at least I'm familiar with, but talk about the jury giving whatever weight it wants to give to that species of evidence. Not that it has a potential for being more outcome determinative than some other kind. That's
Correct.
what's singular about this instruction.
Correct.
Was there any physical evidence presented to the jury?
None.
Okay, so even the shoe was presented by way of testimony.
The same 13-year-old said those were Mr. Lyle's shoes.
I'm sorry?
The same 13-year-old who testified said those were his shoes.
Did the absconding evidence come into the trial?
I'm sorry?
You mentioned that the issue about the warrant and the whole dramatic thumb on the scale of justice. Did the absconding evidence come into the trial?
When you say absconding, you mean-
Absconding.
He
He
absconded
disappeared
on
as
the
soon
warrant.
as the
He-
warrant. Was that introduced?
Yes, that was brought out,
Okay.
that he went. And
That's a conscious what-
also part of the testimony was, when he was arrested, Mr. Lyles gave a statement. He was Mirandized, and gave a statement and explained the reason why he left was because the family was out to get him.
So do
Anything
you,
else?
counsel, do you think that the court applied the right standard of review here? The more probable than not standard? Or do you think they just
I think they applied the
gave
right
lip
standard.
service to that standard and applied a different standard? I mean, that's the question that,
Yeah.
if there's a legal question here, I think that's the question. Otherwise, it's just this court reweighing what the Court of Appeals did below. But if there is a legal question here, I think it's whether the lower court applied the appropriate harmless error standard, or whether they just gave lip service to the harmless error standard.
Relying on the cases that precede the modern harmless error standard.
I think they did apply the correct standard, and they determined whether it was harmful or not. Going back to the previous cases, as well as if I recall correctly, the court even did mention common law.
Well, those cases that say if you fail to give an instruction that what I've characterized as thumb on the scale for this kind of evidence, character evidence, it's fatal, is not compatible with the modern harmless error analysis. Would you agree?
Yes.
Okay. Well, how then should we look at the opinion that seemed to be quite reliant on those early common law theories of character evidence?
All the research that I have done do not come back with this fact-based scenario in this case of a 32-year-old case resting entirely upon the testimony of what was a 13-year-old witness. All these other cases appeared to be factually based on whether the evidence that is presented do apply to character evidence, whether it's permissible or not. Whether or not a defendant has the right to present a defense. Part of the defense, the cases have recognized, can include character evidence. If I recall, one case indicated that might be the only evidence a person would have to defend himself against justice.
But I understand that, but
Okay.
the thing that's critical here is we have a whole line of early cases that precede our modern harmless error analysis that seem to give particularized emphasis on the importance of this character evidence. And so if the Court of Appeals were merely applying the harmless error test, there would have been no need to rely on cases that seem to singularize character evidence. They would have looked at the whole record and said, considering the whole, the non-character evidence was very weak, and so if that instruction had been given, it would have made a difference. That's not quite how the Court of Appeals approached it.
So your ultimate question is
Did the
whether
Court
or
of
not
Appeals-
the current trend in giving character evidence instruction would...
No, it's really simple.
Okay.
Did the Court of Appeals, although it's citing the right standard, fail to apply it?
No.
Okay, that's what I need to understand why.
Okay.
Even though it relied on this line of precedent that all predates 1950 and doesn't square with our current standard for addressing whether an error was harmless.
Because the Court of Appeals recognized that a defendant can present a defense, a proper defense, which can include character evidence, and that wasn't done in this case.
I don't think anybody disagrees with that, and I don't think anybody even
Okay.
disagrees that the jury is presumed to follow the instructions, so the fact the instruction wasn't given is meaningful. We're just asking about what do we do about the fact that the line of precedent that the Court of Appeals relied on, all predating 1950, squares with our current standard for assessing whether an error is harmless.
Agree with the Court of Appeals.
Okay,
Good enough?
got it.
Anything else?
Thank you.
Thank you.
To answer your question, what we do, because the Court of Appeals relied on cases that just don't apply here. They completely ignore the statute requiring that the error must result in a miscarriage of justice. And what we could do is what this court did in People v. Young when it reversed or overruled the ruling in McCoy saying that an instruction on an accomplice witness instruction that's not given is not a rule of automatic reversal. And in Young, this court held that McCoy applied the wrong standard, it didn't apply whether there was a miscarriage of justice, and it didn't go through the harmless error review that was required. And that's what happened here. The Court of Appeals relied on all the cases before that essentially said that there was a rule of automatic reversal, although that's arguable because in each of those cases there was a slightly different scenario that said that they actually instructed the jury not to consider the evidence in certain situations, and they reversed for those reasons. It was two cases, it's People v. Lane and People v. Lewis that actually said that when the instruction is not given, it's a rule of automatic reversal. So the people's position is that the correct standard was not applied. They relied on those cases, and then they came to their conclusion, and then they briefly said that they didn't, in light of the motive and the circumstantial evidence, and the fact that he put a witness on and he asked for the instruction, there was a miscarriage of justice, but
So
there's more.
what should we do? Should we remand it to the Court of Appeals to apply the appropriate standard?
This court could do that. They could remand it to the Court of Appeals to apply the appropriate standard, or they can find that when you apply the appropriate standard, then,
But that's not really work this court does for the most part. Why wouldn't we let the Court of Appeals do that?
okay, this court could have them, you could remand it and have them apply the appropriate
What
standard
should
to
be the
disregard the
What
prior.
should we instruct, if we agree that the Court of Appeals does not appear to have applied the modern harmless error standard, what should the remand say, remand order?
The remand should say that they should be following the statute. They should follow MCL 769.26, and they could pay no attention to the previous cases that held that there was, it's a rule of automatic reversal when a particular good character instruction is not given to the jury. So they have to look at the entire cause to see if it affirmatively appears that it's more probable not that the error was outcome
Are you
determined.
saying that our cases construing that statute implicitly overruled those earlier cases? Do we have to overrule those cases?
Well, not necessarily, because the cases are not all, they don't all say the same thing. So, for example, People v. Lane, People v. Lewis say automatic reversal, but People v. Schultz, which I want to mention because it was not in the People's brief, it's 316 Mich 106 in 1946. This court held that it wasn't a rule of there isn't an automatic reversal. It was reluctant to reverse if there's minimal character evidence, and that's what we have here. We have minimal character evidence. The court should be reluctant to reverse, and they said that the defendant.
Would you agree that our precedent on the value and effect of the character evidence is swirly?
Yes, because this court said in People v. Whitfield, which is the first case on the notes of when this instruction is given, and People v. Whitfield said, actually, good character evidence isn't that important.
What always troubles me is we should always have, as best we can humanly do it, have one clear rule, not rules that seem, or statements in cases that are working at cross purposes and send people in different directions. I think you've described, and I happen to agree with you, those early cases not only are inconsistent with our modern harmless error standard, but they are inconsistent among themselves.
That's absolutely correct. And there is one clear rule that the court should follow and the Court of Appeals should follow, and it's the statute, 769.26, and that just was not applied here. I'd like to point out one more thing, and that's that this is not a defense, this character witness instruction. It's actually not even listed under the defense's instructions that can be given to the court. It's a witness instruction under the general witnesses, along with police officer witness, in that line of instructions. It's not considered a defense for the defendant in this case.
Counsel, you're at the end of your time, but I just have one quick question that kind of goes backwards a little bit, and I apologize for that. But you've described the evidence in this case as overwhelming. I'm not sure I agree with that that's an appropriate adjective, but the question I have is, when you listed what I counted as 5 different categories of evidence or things, you left out the absconding evidence. Is there any reason why? Was that not particularly persuasive evidence?
No, I mean, that's definitely something that that was part of the evidence presented. I think that based on my review of the evidence, his motive and the circumstances of the crime and the witness's testimony, that is enough, that is substantial. I know that defense counsel characterized it as a 13-year-old witness and it's a 30-year-old case. Are we minimizing victim's testimony based on their age of when the crime occurred. I mean, and then the fact that this is an older case, it's not that it wasn't sought to try to push this case through, it's, I mean.
Was there a positive ID? I'm left wondering that too, as opposed to a shadow that smelled and was the same shape? Is that, or did the witness say, I'm sure that was him, or did the witness say that smelled and, was the same shape as?
The witness said she's sure it was him. She knew that it was defendant in front of her walking down the stairs. Her sister behind her said that she thought that it was him. She didn't recognize the smell, but she was further back, and the sister that was walking down immediately behind the defendant knew that it was defendant in front of her. There was actually a light shining through, and so they could see kind of his shape a little bit more, and she was slowing down because she didn't want to run into him. So she knew it was defendant, and then they both immediately told the neighbors that defendant is in their home. So, no, there wasn't a lineup. I mean, he left, the last thing he literally did was get Melvin. So, any further questions?
Thank you very much.
Thank you.
Oh, yeah, when do we come back? Tell people.
Oh, quarter of. We'll return quarter of.